Bismillah ar-Rahman ar-Rahim. This is the third lecture in contract. As we had started last week, we have got to the point to be able to understand the meaning of contractual terms. Any point in the contract, any item, any provision, it's called term. So we can define term, contractual term, we can define it, as you can see here, as any provision forming part of the contract. Any provision, any sentence, any clause in the contract, it's called terms. We would see later on many types of these terms. Can include anything you like, the names, the title, names, location, quality, price, what else? Time, and so on and so forth. Many points can be included. Some contracts can be extended to be hundreds of pages. Some contracts can be only one page. It depends on the type of the contract you would like to undertake. Would it be contract to buy something, like to buy food, to buy a dress, to buy something necessary for yourself, or it can be a transaction which costs millions of pounds, in which you have to write more to explain many items, many points in the contract. So each one of these, as you can see, each term would give rise to an obligation. Obligations. You have two people or more than two people, two parties, and these two parties, each one of them is having some obligations. These obligations came from each term. Like, for example, when we talk about the quality of some items, then my responsibility, my obligation as a seller, to provide you with the quality, and this equality would be as stated in the terms of the contract, and so on and so forth. We can look at many examples like this, but these terms, some of them can be stated in the contract in writing, some of them can be outside this contract. I mean, it's not stated in the contract, but they are implied, implicit. We can understand them by the de facto situation, by the process. We can understand that we have some points, some clauses, some terms, they're not stated in the contract, but they are making part of this contract. Some of these terms can be at the top, or the middle, or the end, on the second page. In all cases, these terms have some importance. I cannot say that, well, the first page of the contract is much important, more important than other pages. No, it can be sometimes equally. Each point, each term in the contract is something important. The problem that some people, some merchants, do not look at all details. They look at few pages, some points, some terms, and then they leave the rest of it. Sometimes there are some terms which can be at the end. They look like insignificant, but in fact they have a significant value. They are really important. Then you can make a mistake in one of these points or terms, then you're going to find harsh consequences. You have to pay for this. You have to pay for this. See, some of them have less legal gravity. Some are so important, and some then less than important. Some of these terms can be at the end of the contract, but even though they can tell what people can do. One of the most important things in a contract is signature when we sign it, because by signing the contract, this means that we have accepted it. But this signature comes at the end of the contract. This does not mean it's, it doesn't have any meaning. No, it's the opposite. Signature is one of the most important points in the contract. This indicates the intention of both parties. They have signed, they have full intention to embrace this contract. It now have significant business consequences. These terms, significant business consequences. There are some common terms, like both parties in the contract state that they do not want to go to court in case of disputes. they want to go for arbitration, they can state this in the contract. This is a common term. They can have assignment and delegation provisions. Assignment, what I can do and what he can do, what responsibilities, what tasks we can have. And we have many types of such terms in a contract. All of them depends on the agreement, because when we say contract, offer and acceptance, intention, consideration, so both parties will have to accept the same thing. General party can only take legal action. If I was myself as a party in a contract, I can take the legal action against the other party if he or she did not fulfill. Like, if I supposed to sell you the car, then you would have to pay the money. If you take my car and you don't pay the money, then I can sue you. I can take legal action against the second party if he or she does not fulfill ينجز. Even if it's not done on time, I can sue that person so he or she can implement the contract on time. This for the contractual terms as a meaning. So we have two types of these terms. Two types. Some of them can be conditions and some can be warranty. They do not have the same consequences or the same quality, the same significance. Some of them, like the names, the quality, these, the title, these are conditions. But some of them can, the time, for example, location, they might be warranties. They're not conditions. So we look at the question of what's the difference. We look at the difference between the two, condition and warranty. Are they the same? Do they have the same meaning? Is it something else? Or we have here, as you can see, that the same point with different meaning. What do you think? Terms can be divided into conditions and warranties. What is a condition and what's a warranty? When we say condition, what does it mean to you? Condition in a contract. It's an important thing? Yes? Is it? Yes? You cannot breach it. Yeah. So conditions are something essential, something important, like quality. The quality is something important. The names, the price, how much it costs. These are something essential to the contract. Now, if one of the parties has a breach the condition, like I'm supposed to deliver to you 500 PCs, and each PC has a specific quality. But then some of these PCs, computers, do not have the same quality. What can you do? What can you do? Can you take an action? Can you sue me? Can you break the contract?
You can sue me.
Sue you.
Go for a charge.
Okay, go on. Here, look. If we have a breach, في تجاوز خلل of these terms, which is conditions, this would allow the second party either had two choices. If it was me, I would have two choices. The second party has a breach one of the conditions of the contract. I can have one of two choices. It's up to me. Either I can discharge, reject the whole contract. We can have rescission. We can reject it. We can cancel the whole contract. Or I would say, okay, I will leave it. I would keep it. Then I would seek damages, which is money damages, compensation. Like this, again, the second example, buying 50 laptops from a company. I received them with a quality less than the quality I requested. Not the same quality, but less than the quality. It's up to me. I can cancel the whole contract. I can reject it. I can take my money back and send laptops to the owner. Or, second choice, I can keep them. Then I would seek for damages, because these computers with less quality would be much cheaper than I requested. Then in this case, I have the choice. The second here, but someone can ask me, like, is it easy? We can know which is a condition, which is not. How can I know if is that term a condition or a warranty? It's an objective matter. I can see sometimes in my eyes that this term is a condition because I can get benefit out of this. But my second party can see or can say that, well, this is not a condition, this is a warranty. So we have a dispute. Then we have to look at the objective side of this case. Objectivity, objective matter, something essential. Who can decide if this term, like for example, quality, is it condition or is it a warranty? Who can decide if it's the location, condition or warranty?
Depends on its value. The whole
Yes, it depends on the value. Like location, most likely, it's not essential. We can deliver the goods to any place. Even if we deliver it to somewhere else which was not stated in the contract, we can re-deliver it. But for some contracts, locations can be essential. It can be something important, and we cannot ignore it. We have to focus on. So it's on the type of the contract. What does it mean? How we can look at it, how both parties can look. But then we can have the objectivity. We can bring someone, a reasonable person. He or she can look at this contract, look at the term, to see if this term, البنديان, if this is something essential, do we need it or we don't need it. Second is the warranty. Warranty is not imperative. It's not essential. Imperative, what's imperative? It's less important. It's not imperative. It's not necessary. And if one of the parties breach the contract only in warranties, then the second party would have only one choice, which is damages, money damages, compensation. If somebody has a breach of warranty in a contract, the second party would have only to claim for money damages, not cancelling the contract. You cannot. It's not here. So the contract will exist. The contract will exist after breaching the warranty, but this would give rise to claim of damages.
I have a question.
Go on.
Can the term be a condition and a warranty at the same time? For example, a warranty to a party and a condition for the other party?
Well, this is one of the most complicated cases. It can, well, how can we look at it? Yes, but we said this is not subjective, it's objective. I can understand that one of the terms for me is a condition. It's really important. But the second party can tell or can understand that this same term is a warranty for him. Then we have to bring someone in the middle, judge, a mediator, to look at this case to see if this is a condition or warranty from an objective, نظرة موضوعية بعيد عن الشخص أنا, away from both parties. Look objectively if this is a condition or warranty, because we have different consequences. In condition we can cancel the contract, we can reject it, but in warranty we cannot. Like for example, if I bought some electronics from China which costing me $500,000, $500,000, then everything was delivered to my place in Gaza City, to my company. But in the contract itself, it was mentioned that this delivery is supposed to be in Khan Yunis. Can I reject the whole contract for this reason? It's not worth it. So I can take the items and the goods and commodities, I can take them from Gaza City to Khan Yunis, and then I can ask for compensation from the same company for that money which I paid for the transportation. So it's not worthy to cancel the whole contract for one not important, non-essential reason. Again, sometimes people can decide which is a condition and which is a warranty. We can know this. Like, for example, look here. Names. What do you think? What can you see? Conditions. Locations. Depends, but most likely warranty. Conditions. Time, it's not sometimes a condition. It can be a condition, it can be a warranty. Timing. Sometimes times is really important. I said, like, it depends. If we have a delay, 1 or 2 days, this will not make a difference. Sometimes it has to be on time. Everything exactly on time, by minute, per hour. In some cases, we can know if this term is a condition or warranty by law. So who can decide? Not you, not me, not the reasonable person. It's the law itself. Statutes, law, legal systems. Statutes may declare term to be a condition or warranty. When we look at commercial law, when we look at civil law, in the United Kingdom, Sale of Goods Act 1979, this is part of civil law and commercial law. 1979 in the UK, this is going to be our next chapter. This act means law, it means code, the same thing, act, law. In this act, 1979, conditions were identified. Some of which here, these terms like title, by the way, means sanad al-milkiyya, title of the property. Description, when you buy a computer, when you buy a car, when you buy some machines, and those machines have to have specific description, exactly as requested. Sometimes computers, you buy them, but you need them for a specific purpose. But then when you get the computer, you don't find that specification. Then you have to change it. Some machines, some cars, when you buy the car, you want a size of the engine. You want a smaller size, but the company delivered to you big size of the engine. That's not something desirable for some customers. And you can take it back. So, description is a condition. Quality is a condition. Sale by sample. Sale by sample. How this will look at it next chapter. How can you sell by sample? I can sell you like 2,000 mobile phone like this, 2,000 pieces of mobile phone. Can take one, and after 2 months, I will deliver the rest of them. The bulk, the whole amount would match the sample. Otherwise, if it doesn't match it, you can reject the whole contract. Again, one of the difficult points and slides here is how can we know if we have explicit or implicit terms? In general, it doesn't matter here to me. If it's a condition or warranty, I don't care. We have some terms here. The terms, hundreds of terms and clauses. How can I know if it's explicit or implicit? Easy. If something was stated in the contract, it's called explicit term. If it's not, we have some terms. These terms constitute part of the contract. They are part of the contract, but they're not written here. How can I know that? How can I know if this contract we have today, this one, includes other terms, but they're not stated in the contract? Like this contract was 20 pages, only 20 pages. But this is not the whole contract. Maybe this is 90%, but there's some 10% of the points are implicit. مفهومين ضمن خلاص. Like what? How can we understand them? We have some examples here. 1, 2, 3, 4.
I think it's something understood by logic. It's something obvious that anyone can understand and know that it's part of the contract.
Well, that's good. Can be understood by logic. Yes, can be sometimes. How can I understand that we have a term? We have different ways. Number one is from the proceedings. From the proceedings we can understand that there are some extra points, but these are not stated in the contract. As a student studying here, do you know how to act? When you came the first time to the Islamic University and you applied to study here for a bachelor degree, accounting or business administration, then when you came for the first time, did anyone give you a guidance how to act? Did you? Oh, that guidance you have, that guide you have, it tells you how to act, how to communicate with people, how to respect the institution, how to pass the exam, how many things and many points. But do you think that this guide and this contract you have, does it include everything about your life in campus? Of course not. No? Okay, what things do you have for the past 2 years or 3 years in your life on campus, and these things were not mentioned in the contract, but you can understand that these points are taken into consideration in the contract? Like what? Uniform. What else?
And the attendance wasn't mentioned in what they gave us. It's all talking about the council of students and how to apply for the university and how to go and take. I don't know, just a few things, not everything.
Yes. In here on campus, you have a different life, and outside at your home, you have a different life. It's not the same. You have to abide by the rules. You have to understand them, and not everything written down. No. There are many things by customs, we can understand them. We can take them into consideration without even looking at them in the contract. In commercial life, in a contract, in civil life as well, you have implicit terms, one of which can be understood from the proceedings. Some contracts take a few minutes to make. Some of them can take a few hours. Some of them can take a few days or weeks. Because I know some of the contracts can be 500-600 pages. To just write it down by the two parties and negotiate it and conclude it takes a long time. We can understand sometimes from the procedures that there are some conditions, some warranties are not written down in the papers, not documented, but we can understand them. We can understand, like what the process itself implied to the process in which the contract was formed. At the time when we were making the contract, which took 2 weeks, they say that 2 weeks or 2 days, in this contract we have negotiations. We have many statements made between us. We have exchanged some promises, but not everything was written in the contract. So we can take these points we discussed in our minds between ourselves, we can take them into consideration once we apply the contract. Okay? And مش شرط نكتب كل شيء. You don't have to write everything. Not to document everything, no. Like we said last time, that in the UK sometimes you can use a note, you can use a document, and this document can be an alternative or a substitute for the contract, even though this was not the contract. As long as you can mention, you can sign, you can have all details on that piece of paper. But this doesn't mean that you can 100% have all information, all conditions and warranties stated in the contract. No. That's one of the cases. Second case is facts. We can understand by fact that there's some terms, they are not written down in a document, in the contract, but we can understand them. Like, what's your name? Summer. What she said at the beginning, you have some information in the book. The time, somebody said the timing, attendance is something existed here. If you do not attend the class, if you miss the class 25% of the time, then you're not supposed to pass the exam. So you have to attend the class at least 75% of the whole time. This is something maybe was not written down for you, but it's something stated at the Islamic University. They have it. But there are many things like, for example, in a company here, working hours. An easy example here, it's how many of you is an future accountant, prospective accountant? How many of you? Are you all business administration? All of you? Unbelievable. Okay. If I ask the opposite question, you would have said maybe yes as well. Anyway, timing. Let's say that one of you is working as administrative officer, administration officer in one of the companies. You've just signed a contract with my company to work full time. We signed a contract for Anud. She's going to be working for my company as a full-time employee. And we signed a contract about the money she's going to get, the salary, how much money she will get, the tasks, what she has to do in my company, for how long time the contract will be, for 2 years, 5 years, depends. All these terms were stated in the contract, but not everything. And she understood that full-time means 40 hours a week. How many hours? 40. By law, it's 40 hours. Thing is that my company works 6 days a week, not 5 days a week. But we did not say this in the contract. Some companies work 5 days, some of them work 6 days a week. So my company works from 8 o'clock in the morning till 2 p.m., from 8 to 2, 6 days a week. But when she came to work, practically, to apply the contract, she told me that, well, I don't like to work according to these hours, because I was thinking that it's supposed to be 5 days, not 6 days, because I want 2 days off. But by de facto situation, by facts, my company existed for the past 10 years. And everybody knows that we have been working 6 days a week. We did not breach the law. We apply 40 hours a week. It doesn't matter 5 days or 6 days. You're supposed to take at least 1 day off per week, and you take your day off. So by law, we are doing perfect. But the mistake here is the misunderstanding. We did not state it in the contract, but by de facto, she has to understand it from the beginning that we work from 8 till 2, 6 days a week. Despite the fact this term was not mentioned in the contract. Same like when you buy commodities, and these commodities you buy them from India. Bring them to Gaza. They take about 2 weeks by cargo, seaside, on shipping them. By the time you get, like, you have to understand the procedures on the port and the tax and the customs authorities, how they deal with you. Things do not have to be stated all the time in the contract, but by fact we have to understand them. So not every term has to be stated here. Even some scholars said, like, even intention, good faith, good intention is a term. For me, I don't think this is the case, because a good faith, being honest, is something basic, something requested by law, by commercial law, by civil law, in our life, in social life. We have to have honesty. We have to have good faith, even if it was not mentioned in the contract. And number 4, sometimes we can learn from previous dealings that we have some conditions, warranties, even we did not mention them in this current contract. A simple example of this is two companies, Company A and Company B. Company A used to buy machines, 10 machines or 10 cars per month from Company B. Every month you have 10 machines coming to the country for Company A. And so we have this every month. So do you think that we have every time we have to make a new contract? No. Even if we make the new contract next time, it doesn't have to include everything. Like you can make a step. Like once we had one of the machines has a fault, was not working well, and company A has accepted this machine, but what it did had compensation from company B. Compensation because the machine was not as good as other machines, so we can get compensation. So, and that was fixed between the two companies. In the future, this will become a tradition. This will become condition, will become term in the contract. So each time in the future we have the same situation, we can apply the same deal. Then next time, we don't have to write it in the contract. In the previous time, in the past, we have dealing, trade, practice. Practice, خلاص. Customs, something we know. Good? Do you understand me well? Yes. Are you sure? Perfect. This is a little bit difficult than the implied terms we had before. It's implied in law. This is implied in law. In some countries, some places, what they do, they have the contract written down between the two parties, and on the back of the contract, they copy and paste the law. So you can look at the back of the page, and you can see the law itself stated. Well, not everything in the act, but the specific points which are connected with this contract. But even here, I'm saying, even if you don't mention that, even if you don't copy and paste, you have to understand that the law itself is implicit here. The law itself is implied in the contract. How is this? We're going to look at this in more detail next chapter. When we look at the Sale of Goods Act 1979 in the UK, we'll look at how can legal terms be implicit or implied in the contract. Here, this contract is supposed to mention many points, but not everything in our life. Not everything has to be included in one contract. If we have a shortage, if we have a fault in the contract, then we can go back to the law. If we have the contract and the law, which one comes first? No. Contract comes first before the law. Contract comes before the act. Source number one, sources here. Sources of commercial law and civil law, the same thing. Sources in a private law. Contract comes the first. في العربي بنسميها العقد شريعة المتعاقدين. العقد. The contract is the law between the two parties. The law between you and me, the act, is the contract we have. Not going to the country law. No, it's not. If we have missed one point here, if we have any problem together, we cannot explain it. We have shortage. We can go back to the number two here. Number one is contract and number two is the law. So if we have a dispute between two merchants, we have to go back first to the contract. If we find a solution, that's perfect. If we cannot find a solution, go back to the law. So we can apply the law only in one case. If we have a dispute, here, talking about commercial law, if we have a dispute and there is no solution in the contract between the two parties, then we can apply the act, the code, because the contract has come first. Now, each contract we have, each contract here, any contract we make today, if you would like to make a contract with you, this contract would mean here, this contract would include it would include the law or the act automatically, without noticing. Why? Because these terms in the law here become implicit in the contract, implied in the contract, even without mentioning that. Even so, these terms in the contract are expressed, but terms in the law are implied in the contract. Do you get the point?
Yes.
See that the name, location, equality, price, these what we call them
Contract terms.
explicit terms in the contract. You can see them?
Yes.
Explicit, واضح, clear. But these terms in the law, they are implicit in the contract because they are not stated here. They stated somewhere else. But we can understand that these are included. يعني فاهمين ان هم داخلين في العقد بدون ما نذكر ذلك. ضمنيا. They are included in the contract. Difficult? Okay. Give an example so you can understand it. One of the cases was in Liverpool in the UK. Liverpool City Council, we have a tenant, so a landlord, the owner of the house, and you have some tenants, landlord and 4 tenants, students studying at university, and they rented a flat, and the flat have 4 bedrooms, kitchen, bathroom, sitting room, balcony, and you have washing machine, fridge, and other things in the house. Now, who's supposed to fix the washing machine if it does not work? The landlord or the tenants?
Tenants.
Why?
Because they use it.
They use it. Okay. Well, they use it, but they pay money for the landlord. Do they?
Yes, they use it, but they own it in the city.
Well, this is not the answer, of course. It can be, but it's not. Who's supposed to maintain the common area, like the sitting room, the washing machine, the TV? Who's supposed to maintain them?
Landlord?
Why the landlord? It depends. That's the answer. It depends on these terms. Well, look, I came as a tenant in your house, in your flat, and then I signed a contract. We look back. This contract, what does it say? If it says that common areas, المناطق المشتركة يعني, sitting room, the kitchen and the bathroom, if it says these have to be maintained by the landlord, that's fine. If it says they have to be maintained by the tenants, that's okay. It depends on the contract. You can state anything in the contract, and we have to abide by the contract unless, see, anything in the contract comes first. Unless these terms in the contract are illegal. What do you mean by illegal? Are inconsistent with the public interest. Public, not a private. This is a private law. If these contracts here are inconsistent with public interest, or they were against public policy in the state and against the whole society, this will be illegal. The whole contract. But as long as this private law, it's fine, because private law comes to respond to the need of the society. So in that case, we look back at the contract, whether the landlord or tenants. The problem is we do not find a solution there. If we don't find any term, what can we do? In this case, we do not find solution in the contract. What can we do? We'll go to the law. Because the law is implicit in the contract, isn't it? Yes. Implicit. The law says the landlord is supposed to keep the common areas in a reasonable state of repair. That's according to the law. But if we can change it, in the contract we can say that tenants supposed to fix the whole thing. It's up to you. This is not saying something illegal. No, it's legal. It's fine. Yeah. Going back to the same point here, one of the important legislation under UK law is Sale of Goods Act 1979, which we have to look at next week. I think next week when we look at chapter 4. This 1979 Act in the UK, Sale of Goods, have implicit terms, like the same case here. Let's say this is the code, this is the code, this is the Act, 1979 Act. It's all implicit in the contract. Sometimes even we have specialized statutes that deal with particular subjects. They can be included. Not even in general, sometimes with specific cases. These points, there are some law, like even today we have acts, codes, legal acts for everything in our life. We have medical act, financial act, tax act. Everything in our life, you can imagine that we have a special act or code, which is a law. Then that can cover every little aspects in our life, so we can have specified here, specialized statute. So if we have any dispute or any conflict, go back to the same statute, which can respond to our needs. Because if we have conflict, this is the only solution.
Constitution,
Yes. No, it's not. No. Constitution is the highest piece of law. Constitution has general policy in the country only, no details. Constitution will look at the political aspect and the general policy, and will look at the freedom, the rights of the people. But when we talk about here, these statutes, قوانين, like civil law, administrative law, commercial law, and inside them we find nowadays, you find insurance, maybe compensation act, tort act, taxes, and other things, other subjects. These are included under private law. See, can you read this here?
Most countries, for example, have statutes which deal directly with the sale of goods, lease transactions, and trade practices.
Yes. For example, most countries, like in the UK, they have 1979 Sale of Goods Special Act. This is supposed to be civil law or private law, and civil law or commercial law, sorry. And even under that, we have specific subjects, and even have lease transactions. عقد الإيجار. You can have sometimes special law for that. It's not worth it, but you can have it. You can have trade practices. Trade, how can you practice business in the market? Everything nowadays is going towards specializations. We have to move to this subject, which is much easier, and it's a long subject, which we cannot finish it by today. But at least you can take into consideration the fact that many questions in the exam would be out of this subject here, setting aside the contract, because it's something really practical, important, something we can face with many times in our life. How we can setting aside the contract, meaning by this, how can we cancel, how can we void, like meaning one of the 3 points: void, voidable, and unenforceable. How a contract can be void? Void, it means it does not exist at all. There was no contract. Fish. It implies that contract has never came into existence from the beginning. Like if we have no intention, if we miss one of the conditions, the contract can be no contract. If we miss the offer or the acceptance, or there was no value, or there was no intention, this is not a contract, because the contract means 3 conditions. It's called void, 0, nothing. Second one is voidable. It's not void, but it's voidable. قابل للإبطال. ممكن. It's possible that we can void the contract. Who can void it? One of 2 parties. One of them. Can you read it? Go on.
Voidable implies that one or both parties may declare a contract ineffective at their wish.
one or both of them, maybe A or B, any one of them or both at the same time can declare that this contract is ineffective. Ineffective. We don't need it anymore, because one of the cases, like we said before, that if one has a breach condition, then the second has one or two options: either cancel or make the contract ineffective, or can ask for compensation. And the third point is, how can we set aside the contract? Is it can be unenforceable. We have a contract. In fact, in this point, there is a contract, but we cannot force it. And I guess that we have this point before. This is not the first time we have it. Not in a quasi contract. That's if we had to have the contract in a special form. So condition number 4, which is additional to some contract, if by law there is a contract and it's supposed to be in a special form, and this contract was not written in that form, none of the parties can force it. And we had this case last time.
Renting houses, leasing apartments.
Yeah, like selling a house, a car. You have to write the contract in a special form, and it has to be authorized by official authority. And if you don't have it in that official way, then this contract cannot be enforced. Like, I can sell a house, a car, but I have to write the contract in a special format. It's not enough to make an offer or acceptance to pay the money to get the car. No, you have to make it in a special format. If you do not meet this condition, then you will not be able to enforce the contract. Do you get the point? I did explain it last time. Okay. I'm going to explain it later on, but anyway, no, I would have to explain it now. One of the cases, the contract has to be in a special form. And I said 99.9% of the contracts are made orally. Very few contracts are made in writing, in documents. Some contracts have to be by law written down officially. The Act asks people, you have to write this contract. Like, to sell my car to you, what's your name? Hany. I want to sell my car to Hany for £5,000. Then I made the offer, she made the acceptance, and we have the intention. Then we have to deliver the car and the money. But this contract is valid contract, but it needs only one extra condition, which is one extra condition. We have to write it in a special form. It's not enough to make it oral. We have to write it in a special form. We can go to the Minister of Transportation. We can sign the contract there. Okay? Now, if we don't sign this contract, we cannot enforce it. Like, now, after we made the offer and the acceptance, and we have the intention, we have to exchange good and the money, car and the money. Now, if we do not write in a special form, she cannot force me. If I change my mind the last minute, if I change my mind, then she cannot force me to give her the car, or I cannot force her to pay the money. But if it's a contract which is a normal contract, does not have to have special format, then it's enough to make the promise. It's enough. Now, in this case, the contract, the case we mentioned about the car and the money, it's called unenforceable. It can be sometimes unenforceable because the contract does not meet the conditions. It can be sometimes illegal contracts. It is a contract, legally it's a contract, but it's illegal. Like selling drugs, selling weapons. It's a contract. People make a contract, but you cannot enforce it because the purpose of that contract is illegal. So this is unenforceable, despite the fact that contract was fine, has all the conditions. You cannot sell slaves. You know what slaves? And nowadays, even you have in the world, many places, people having slave trades, even having children and women trades in the world. It's flourishing nowadays, by the way. Flourishing. Many companies, many gangs around the world are selling kids, children, women as slaves. Many places, I can't specify which country, but many countries around the world, they have this business. It's illegal. The contract itself can exist. You have offer and acceptance, conditions, offer and acceptance, intention and consideration, but the contract is unenforceable. Why? Because the purpose is illegal. Let's start with the first point. How can we set aside the contract? How can we set aside the contract? By many ways, by many means. Number one, it's called misrepresentation, which means false statement made by one person. And this false statement, look at it, false statement of what? Fact may be made by one party to another and has the effect of the second party and inducing that party into the contract, making false, lying, false statements, saying, well, this laptop has an amazing quality. This was made in Finland. That's it's not the same. You call that false statement, misrepresentation. Represent اللي هو يعرض أو يوجه. Misrepresentation, giving false statements to the second party, and because of this statement, the second party has made the contract. If he or she does not know from the beginning this equality, like believing that this laptop has a specific equality, and I bought it for this equality, and later on I realized that this laptop has no quality, not the same description I wanted. Here, quality or description or nature, it's not the same. Then it was a false statement made by the seller to the buyer. Now it's my choice. I can void the contract. I can ask for compensation, or I can void the contract, because false statement of fact. That man telling me, well, this computer has a hard disk of 500 giga, for example, but then I find it only 50 giga. Isn't that false statement? It is false statement. Fact or is it opinion? It's not his opinion. He knows. He told me this has these specifications. Memory 4 giga, and in fact I found it only 1 giga. Is it the same equality I wanted? It's not the same equality. And even sometimes the nature. Like the paint. See the paint, how many colors we have? This paint has a nature. Some of the paint can be used for the windows, the glass. Some of them can be used for the concrete, for the wood. It's not the same nature. Even cement, sugar, they're not the same equality. Some of them diet, like using for some people who are looking for the brown, for example, brown sugar or white sugar, they're not the same. Now, somebody making false statement on one of these points, it means the second party would have the right to void the contract. Here. False statements regarding the quality of nature may constitute a misrepresentation. Finding of this misrepresentation allow for remedy for rescission or money damages. It's up to the second party. You can take rescission, you can take money compensation damages, or you can ask for rescission to cancel the contract. Cancel it. This false statement, it can be like misrepresentation. It can be made by words, by action, by conduct. I can imply to you, well, that machine is the best machine in the market, and this machine can manufacture materials. But in fact, it does not. I can imply this to you by act, by showing you something, but in fact it's not. By saying something, so it can be by conduct and it can be by words. Misrepresentation has to be false statement of fact. Keep in your mind, this is important. Fact. Lying about fact, not opinion. Because here, statement of opinion, it's not the same. Statement of opinion are not statement of fact. And this was many times a question in the exam. Statement of opinion, it's not a statement of fact. They're not the same at all. If I say, well, I think this is a HP computer, was made in Ireland and has a memory of 4 gig. I think so. This is my opinion, isn't it? It's not a fact. I have no idea. I did not make it definitely that this computer has those specifications. I cannot say that this sugar is sweet enough or not. I think this sugar is sweet more than the sugar we used to buy from India. Or I think, let's say, it's an opinion. It's an opinion here. Opinion they are not a statement of fact in the context of misrepresentation. So, if it's a statement of opinion, does it stand like a statement of fact?
No.
It's not. So, if I make my statement as of opinion, this will not affect the contract, isn't it? If I lie to you, lying to you, saying, well, this is a bottle of petrol. Inside it is a petrol. And you find it's not, it's water. This, well, it's a statement, false statement of fact, because I know what's inside it. But if I say to you, well, I don't know, I think, in my opinion, this bottle is not a bottle of water, it's a bottle of gasoline. I think so. What do you think? Can my statement stand as a fact?
No.
It's an opinion only. It's not. So my statement, if I say I think, on my opinion, this cannot affect the contract. It's not a misrepresentation. So misrepresentation can be false statement of fact. Made by one, made by A. This induced دفعت B to make the contract. If I knew from the beginning that this item does not have what I want, then I will not have bought it from the beginning. But because of what you said to me, because of what you made, because of the false statement, I made this contract. If I knew from the beginning that this statement was not fact, that was not a real statement, then I would not have bought this item. Fine? Again, for the same point here, false statement of opinion. Can we say that we have false statement of opinion? Can we?
No.
We can say that we have false statement of fact. Lying, saying, well, this wall is made of concrete, but in fact is made of wood. Wood. Some of the walls made of wood. It's a fact. But if I say that in my opinion, or I believe so, it's not. So a statement of opinion, it's not a statement of fact. Except in one case. Only one situation, a statement of opinion is equal, exactly. The same like if it's a statement of fact. And in this case, a statement of opinion can affect the contract. Then the second party can have a rescission or money damage. This is the case of here. One party claims special knowledge. One of them is expert, special knowledge, saying, well, I'm an expert, and everyone knows that I'm expert in electronics. Someone really is expert in his own subject, then he makes an opinion, then his opinion is equal to a fact. When you go to the medical doctor for a checkup, medical doctor, do you take what he says to you as a fact or as an opinion? Even if he says, well, this is my opinion, I take it as a fact because he's a specialist. When I go to an engineer, I want him to make a map for my house. my house, to build the house, then what he says to me, I take it as a fact, even though it might not be a fact, it might be an opinion, but his opinion is equal to fact. When you go to economist, and that economist tells me, well, the pound today is not good, but in 6 months' time, the pound would have a good value. After 6 months' time, the pound will equal $2. Then I change my money, depending on his opinion, because I think or I believe that he has a strong opinion. He's got a realistic opinion. He's expert. Then I change my position based on what he said to me. In this case, then go on.
It is more likely for the court to hold a statement of opinion as a statement of
Yes. The court can say, well, this statement of opinion is equal as a statement of fact. And then that man or that lady, as expert, having special knowledge, will hold the whole responsibility if there was any mistake. Go on, ask. دخل مين? Okay, لا. If I sell computers, I bought my laptop from somebody. He has a store. But I know that person who sells computer, he is a computer engineer. And he is a specialist in computer. And I went and bought from him 5 laptops from my company. And he said to me, in my opinion, he said that this type of laptop is the best in my place. And this laptop has many qualities, and he counted these qualities for me. And based on what he said to me, I've taken these laptops. After a few days, one of my friends, as expert in computers, after looking at these computers, finding these computers do not meet the specifications I wanted. Then, because I, based on what he said to me as his opinion, I bought them. His opinion is equal to a fact, so I can take these computers back to him, say, well, I don't want them anymore. Isn't it? Yeah. Do you have time or? 5 minutes. Okay, well, leave it up to this point. Next time we will look at mistakes. Next time we have to look at mistakes. And thank you for your time for today.